I choose the example of the EU regulation, which are familiar to you, of course. But let me start with some introduction. About the terms which are used in my presentation. Of course, you know that the terms diplomatic protection and consular protection or assistance comes from the international general law. And we are, as citizens, are protected by our states in two ways, in diplomatic protection way and consular protection and assistance way. Let me start with consular assistance. The term consular protection and consular assistance both are not defined in the Vienna Convention on Consular Relations. And the term consular assistance seems to me to be the best term to describe consular activities which are performed by the states, because they combine those two elements, helping and protecting. And the states are also using the first term, so consular assistance. For example, the British Foreign Commonwealth and Development Office on the website states that consular assistance simply describes the support and help of this office can provide to British nationals if they got into difficulty whilst living or traveling abroad. And this includes, for example, of course, supporting those who have lost their passport, been a victim of crime, or who have been hospitalized or arrested. It is also used by some organization, international organization, and in Polish consular law also we have the assistance, consular assistance, because according to our consular law, as we see, the consul provides assistance to a Polish citizen, in particular in the event of a serious accident or serious illness, arrest or detention of that citizen, and an act of violence of which a Polish citizen has fallen victim, and the death of Polish citizen, the need for a sudden return of a Polish citizen deprived of financial resources to the Republic of Poland or to the country of residence. So we have the examples of what is the consular assistance according to the Polish law. And that was easier to present. And now we have to get to the diplomatic protection. We have formal definition of diplomatic protection, and this definition shows that it is not really that kind of protection that we the most community assumes, because this is not the matter of diplomacy or even human rights. And according to that definition, which is prepared by the International Commission in the draft from 2006, diplomatic protection consists of the invocation by a state through diplomatic action or other means. So not only diplomatic action, other means of peaceful settlement of the responsibility of another state for an injury caused by an internationally wrongful act of that state to a natural or legal person that is a national of the former state, with a view to the implementation of such responsibility. So the main feature of this definition is this is about the responsibility of states. And according to the commentary to this definition, the definition views diplomatic protection through the prism of state responsibility and emphasizes that it is a procedure for securing the responsibility of the state for injury to the national following from an internationally wrongful act. And the question whose right it is the right of a person to be protected by diplomatic protection, or it is a right of a state. And the definition, as the Commission by itself stated, this definition leaves open the question whether the state exercising diplomatic protection does so in its own right or that of its national, or both. But still, according to the traditional classical international law, this is a state who has the right to exercise diplomatic protection on behalf of its national. It is under no duty or obligation to do so. Only the internal law of a state may oblige a state to extend diplomatic protection to a national, but international law imposes no such obligation. So, maybe to conclude, diplomatic protection, maybe because I will try to. Sometimes we heard about the diplomatic protection in informal sense. What could it be, this diplomatic protection, not in formal sensu stricto, but in formal sense? The people think that diplomatic protection is the protection which is exercised by a diplomatic mission. And of course, according to the Vienna Convention on Diplomatic Relations, which lists among the basic functions of diplomatic missions, also protecting the interest not only of the sending state, but also of its nationals. So this is the first informal meaning of diplomatic protection, the protection of interest of its nationals. And of course, it is also somehow shortcut. So, because the diplomatic missions may also perform consular functions by their consular sections. That's why almost the whole population thinks that this consular assistance is diplomatic assistance. It is not, because this is only diplomatic mission who perform that functions, but what is really done is consular functions. So the consular assistance by diplomatic missions, by the consular section in that mission. Of course, the real diplomatic protection, in the formal sense, may be exercised through diplomatic actions, because the actions cover all the lawful procedures employed by a state to inform another state of its views and concerns, including protest and requests for inquiry or negotiations, aimed at the settlement of disputes. So somehow, what diplomatic agents is acting is also the real diplomatic protection, when they are invoking the responsibility of other states. But such activities like démarches or other diplomatic actions that do not involve the invocation of the legal responsibility of another state, informal requests for corrective action, are not the acting in diplomatic protection. Now, to conclude, so diplomatic protection in formal sense must be connected with the responsibility of states. Some forms of diplomatic protection in formal sense may be exercised by a state through the actions of its diplomatic agents, but the aim of the action must be to invoke the legal responsibility of the other, so in practice, the receiving state. But other activities of diplomatic agents that involve the protection only of the interests of the nationals in receiving state may be called diplomatic protection only in informal meaning, but in most cases, the term diplomatic protection is used simply as a shortcut for the performance of consular functions by the consular sections of diplomatic missions. So this is the introduction to feel better with the terminology. What is in reality diplomatic protection and consular assistance? And let me go to diplomatic protection and consular assistance and the EU citizenship. You perfectly know that we as EU citizens have the right to protection, but do we have the right to diplomatic protection or not? As we see in Article 20, the citizens shall have, inter alia, the right to enjoy in the territory of a third country in which the member state of which they are nationals is not represented, the protection of the diplomatic and consular authorities of any member state on the same conditions as the nationals of that state. So it is not mentioned that we are entitled to diplomatic protection and consular protection. We are entitled to the protection by diplomatic and consular authorities, and this is not the same. The wording of the other articles from the Treaty of the Functioning of the European Union use also the terms protection by the diplomatic and consular authorities. Also, the Charter of the Fundamental Rights is stated about the protection by the diplomatic and consular authorities. Also, the title may be misleading because we have the title of the Charter Diplomatic and Consular Protection. This is not some inconsequence.
Protection.
Yeah. And that's why some, let's say, some suggestions in the literature are that maybe we have the right to diplomatic protection. What are the arguments for that? So, as I said, the title of the of Article 46 of the Charter, and the German version of the Treaty of Functioning of the European Union. Why? Because not in Article 20, but 23, the content refers to diplomatic and consular protection. And in German text it is diplomatischer und konsularischen Schutz, of course. But still, in Article 20, also in German version, which speaks about protection by the diplomatic and consular authorities. So this is, I think, misleading. But only in the German text of the Treaty of Functioning of the European Union we have such inconsequence between Article 23 and 20 of this treaty. What is an argument against, and I'm sure that this is the right way to interpret this treaty. So in other languages, Article 23 speaks of the protection by the diplomatic and consular authorities and not about diplomatic and consular protection, and also the content of the charter. But for me, the most convenient argument is the very essence of the diplomatic protection, simply. Because whether a member state is entitled to provide diplomatic protection for Union citizens who are not its nationals cannot be resolved unilaterally by the European Union. European citizenship itself does not provide a sufficient link to to fulfill the requirement of nationality, because in general international law we should have the link between the state and the person, and the link is nationality. So the European Union cannot unilaterally change this rule simply. To conclude this part of presentation, I'm sure that the right of European citizens to protect by the diplomatic or consular authorities means simply the right to consular protection or consular assistance. That should be performed both by embassies, consular sections, and the consular posts by themselves. And I found such an information, for example, on the European Commission website. As an EU citizen, you are entitled to seek help from the embassy or consulate of any other EU member state if you need assistance in a country outside the EU where your own EU country does not have an embassy or consulate. You are unrepresented. So these are the main conclusion that the whole regulations concerning the right of EU citizen to protection abroad is about only consular assistance, not diplomatic protection in a formal sense. Let's say the legal basis for the protection of EU citizens abroad. We have two Council directive. We have the first and the most important directive on the coordination and cooperation measures to facilitate consular protection for unrepresented citizens of the Union in third countries. The goal of this directive is simply to outline the right to consular protection with some definitions and procedures necessary to implement it. We have also the directive concerning the establishing an EU emergency travel document, but this is the new regulation which is in force but can be used only in 1 year. And we have also the Council decision establishing the organization and functioning of the European External Action Service. I mentioned this decision because Article 5.10 of this decision states that Union delegations are to support member states in their diplomatic relations, of course, but in the role of providing consular protection to citizens of the Union in third countries. So this is the basis, the legal basis for some activities of the Union EU embassies, because they are simply the mission of EU abroad. So these are legal bases. Now I will concentrate on the directive from 2015, the first directive. Its goal is to ensure that unrepresented EU citizens receive help from other member states consular services in emergencies. What are the main features of this directive? Of course, the obligation that member states' embassies or consulate shall provide consular protection to unrepresented citizens on the same conditions as to their own nationals. Unrepresented EU citizens means every citizen who holds the nationality of a member state not represented in a third country. So we have the definition by definition. So we don't have the definition of unrepresented EU citizen, but the definition of what does it mean, member state which is not represented. The protection is also for the family members, and a member what does it mean that the member is not represented, so a member state is not represented in a third country? The first situation is obvious. The member state is not represented if simply it has not an embassy or consulate established there on a permanent basis. But the second situation is more complicated to assess, because it is also in that situation when there is an embassy or honorary or consulate or consulary post or honorary consul, but they are not effectively in a position to provide consular protection in a given case. And as I will present, this is the biggest problem to assess what does it mean to be effectively in position or or not be in a position to provide consular protection. What is the scope of assistance? The scope is only the 6 activities, but happily we do not have the close list, but with the verbs inter alia. So we have on the list arrest of detention or detention, being a victim of crime, a serious accident or serious illness. We have death, of course, relief and repatriation in case of an emergency, and need for emergency travel documents if somebody left or the documents was stolen, for example. Of course, the directive also states some rules concerning the procedure of this consular protection, and, for example, regulates the reimbursement of costs. Maybe I should somehow shorten my presentation. What is the problem? What are the currently circumstances in which that directive is used? The scale of a problem is, for example, in 2020, close to 13 million EU citizens did not have a consulate or embassy of their member state of nationality that could have effectively provided them with consular assistance services in third countries. But I think it is not about the effectivity, but I found such a statistic. They really simply don't have physically embassy or consular posts. There are only 3 countries outside the EU where all member states have a permanent representation. That are China, Russia, and US. I check it on the website of the European Commission. Only 5 of the 27 member states have representations, EU members, have representations in more than half of the countries. And what I want to stress, on average, the consular network of all the member states is lower than the EU delegations network of the European External Action Service. Thus, in many third countries, only the EU is represented, not the states. The impulse to choose for the topic in itself, but also the EU regulations, was the information that in December 2023, the Commission brought forward a proposal for a Council directive to amend Directive 2015. Time, okay. That was the purpose also for sure was to facilitate the protection, and the background was that there was some circumstances which, let's say, stress the gaps in this directive. It was the COVID pandemic, the crisis in Afghanistan, Russian war of aggression against Ukraine, the conflict in Sudan, and repatriations from Israel and Gaza Strip, and other similar cases. And so these are the problems in practice. Maybe I would only stress that the number of unrepresented EU citizens in third countries will most likely increase. Why? Because of shrinking consular network among member states due to fiscal constraints and due to withdrawal of the United Kingdom. And also an increasing number of EU citizens traveling or residing abroad. So the need for somehow improving the directive is really very big. And what is proposed? Some clarifications regarding the term unrepresented state. So we will have, if the proposal will go further, we will have some criteria to be taken into account to assess whether the consular post or embassy is effective in position to help simply. And we will have, for example, the criteria that concerning honorary consuls, because in some situations the honorary consul does exist in some country, but without competences. And this is stressed in the proposals that if the assistance requested by the citizens is covered by the competences of the honorary consul, it is the possibility to protect. But if not, it is not. And I think it's the most important change which is proposed. The other, in my opinion, is not so important. For example, the new term evacuation in the scope of assistance. More institutions may be involved in coordination and cooperation. Some obligation concerning registration and information. I'm sorry, but I would like to simply go faster. That's why I maybe in the part of questions discussion may come back to that. And new rules concerning cost reimbursement. That will be the proposition to. That the state may get this reimbursement directly from the citizens which were unrepresented, and we will have right to effective remedy. We are after the opinion of European Parliament, who proposed some other proposition to amend this directive. In my opinion, the most interesting is the proposition concerning refugees and state-led persons. I have the whole proposition here, but in my opinion, the good solution is the proposal of the European Parliament about the extension of consular protection to refugees and state-led persons who reside in a member state and are holders of a travel document issued by that member state, because of the number of refugees and state-led persons in some huge crisis of some migration crisis, for example, from Ukraine. In my opinion, of course, the good solution is that with honorary consul. but we will have also some rules, strict rules concerning the assessment. What does it mean to be in position to, effective in position to help? And this criteria are the closed list. So in my opinion, this is not good solution, because in many situations the reason should be the first criteria to assess that situation. So the fact that we will have some criteria is not good in it's not bad in itself, but it should be not the closed list of this criteria, but inter alia, for example. So I prepared 40 slides, and I knew that it is too much, but still I will answer any questions if you will have it. And the proposal of the changing is awaiting for final decision of the Council. And the last slide is thank you for your attention.